it would help if I turned the microphone on. So after all of that, you didn't hear any of it. So now you can hear, I hope. So anyway, thank you all for being here today. And we are at the Greater San Diego Association of Realtors. And my name is Kevin Burke, and there is my telephone number. I would really just as soon speak with you, although sometimes we've got to set up a time and maybe have to send an email and do that. But please, if you try to reach out to me and I don't respond, hit me again. Give me a couple of hours, because it may very well be that I'm in the middle of another webinar, for example, like this now. But give me another shot at that. So thank you. And I should tell you, this is being recorded, and nobody can see you. And in fact, nobody can see the questions that you put into the chat line. So, or into what we call the, not chat, but the Q&A field. So nobody can see you. So anyway, hi, Linda. So just want to let you know that, so you don't have to worry about asking. People say all the time, they say, well, I don't want to ask a question because it'll be stupid. And it's like, there's no such thing as a stupid question, just people not asking the question that ends up becoming stupid. So let's ask the questions. Okay. So anyway, that being said, I have been told by the chair of education this year, Judy Preston, a wonderful lady, that I need to slow down a little bit. So we're going to do that today. Let's see here. So on the left-hand side is a whole bunch of stuff that I've done in the past. And as I've always said, awards are for things you've done in the past. What are you doing today? And so I have a broker's license in several states. Been in real estate for over 40 years. Got my license my first license in 1979. And of course, some of you on this call today have been licensed way before me. I thought that I didn't know anybody was alive then, but anyway, thank you. And Joe, always thank you for being here. I do teach continuing education for attorneys at UCSD. Real property law, and I've been teaching that for probably about 25 years now. So it's been quite some time. And I always tell everybody, are you in the real estate practice? And I say, no, I'm in the real estate perfect. Practice makes perfect. And so I've been doing this long enough that I think I'm getting a pretty good handle on things. But the one thing I am is I do leave myself open to learning new things every day. And as long as you can leave yourself open to that, then it's a much better environment for everybody, rather than those people that I have to deal with who just plain know everything. And so we got to be careful about that. So on the right-hand side, and unfortunately, I didn't change this, but last year I was the chair of risk management for the National Association of Realtors for the West Group. And then in California last year, I was chair of risk management and consumer protection. Next year, I will be in charge. I will be the chair of the Legal Affairs Forum. And I will also be the chair of the Expert Witness Forum. So I guess they're keeping me busy, right? So, the one thing we always learned in the military was don't volunteer, but I keep getting volunteered, as it were. So we're going to be talking about stuff that's going to appear to be legal. I'm not a practicing attorney. I have no intentions at all. Let's just leave it at that. I do a lot of trial work as an expert witness. And so again, I'm a court certified expert witness on standard of care. Did the real estate agent do what they were supposed to do? What should they have done differently? Things like that. Okay. And I should probably pause here just to make a note. So this is being recorded, which means after we're done, I'm going to load it up onto the YouTube website. So at a certain point, I'm going to say, get your QR code reader out there so that you can take a picture of it and it'll take you to the website. So I had to learn how to do QR codes because it wasn't happening. Nobody else was doing it. So I had to do it. And so from that, I learned how to do bit.ly links. I learned how to do I've learned how to do a lot of stuff. So learn how to do things. I mean, if I tell you nothing else, at least learn new things. And so what else? Agents' duties of inspection and disclosure. We're going to talk a little bit about that today. And then market conditions, specifically in San Diego County, but I get asked about market conditions all over the country. So, it's a good gig, as we say. Conversation today not intended to be a substitute for the advice of your broker, nor for that of your attorney. Please consult with them as appropriate. Now, if I'm your broker, then you need to consult with me. Okay. And if you're your own broker, then you need to be talking to yourself, right? So, That being said, our talk today is intended to be interactive, so please ask questions or offer input by utilizing the Q&A button. Okay, so the Q&A button got used a lot this morning. This morning we did a talk on all about disclosures, and interactions were great. People going back and forth. And again, I've already loaded that up onto the YouTube website. Should be there already, so it's up there. I do look forward to hearing from you. So please don't be shy. Ask questions. Again, nobody can see them. I may repeat the question in a way that so everybody will understand what I'm looking at, but nobody can see them on the screen. Okay, I can see them. Okay, so this morning we did all about disclosures, and now we're going to do the TDS, the SPQ, the SPQA, and the Avid. Okay, so Linda is home. So I have this thing that I turn on all the lights for Linda so that she doesn't come into a dark house. But let's see, middle floor on. There we go. Okay, so disclosures on Thursday morning we'll have a discussion regarding the differences between our statutory and our contractual disclosures. We talked a little bit about it this morning, and you can't help it, you've got to talk about it, but I'm going to go into depth into those disclosures on Thursday morning. And then on Thursday afternoon, one of my hit presentations seems to be mastering my farm. And if you're not making money in real estate, which is kind of the general idea, I'll help you do that, because I want to see you do well. Okay. And so taking over your neighborhood kind of thing is pretty important. I would recommend that you establish a game plan, and that's what I will help you with on Thursday afternoon. And then the following week, by the way, is the last week for our training sessions. We will probably do classes on Tuesday and Thursday, and then we're done until I don't know. They don't have me on calendar, so I may be finished. I don't know. But anyway, we'll see what happens. I know that education is meeting, and they're going to go over some of the possibilities of the world and all that. I personally think these 2-hour webinars are a little bit long. I can fill them pretty easily, but because as you could probably figure, I do a lot of research before this stuff comes out, and so you're going to get the best of it, as it were. And so anyway, that being said, thank you again today for joining us. We're going to talk about the TDS, the SPQ, the SPQA, and the Avid form. So we're going to talk about all of those things, okay? And so we're going to drill into these. These are among my favorite subjects, and if I'm going to get hauled into a lawsuit, it's going to be this, okay? So it's going to be these things right here. So why are they required? And so in California, there is no buyer beware. There is, however, caveat vendor, which is let the seller beware. Some of this for those of you, let me see, show of hands, how many were there this morning? Oh, a couple of us. Okay, not bad. But some of this may sound like a little bit of a repeat, but we're going to cover a couple things, and then we're going to launch into this. So why are they required? Again, the seller, why is the seller required to make the disclosures? To assure that those with the most knowledge of the property share that information with the buyer. And then as far as the agent is concerned, to assure that the real estate professional does their due diligence in the real estate transaction. So let's talk about Easton. We're just going to look at Easton really quick. I'm not going to spend a lot of time on it. We spent a lot of time on it this morning, but I want to just talk about it really quick here. The Easton case, probably one of my favorite cases. So I've given you the highlighted version of it. So just essentially the gist of the Easton case was this is a transaction that occurred in 1978, I think it was. Easton was a buyer, Strasburger was the seller. The seller was aware of problems with the property. They'd had their own soil disasters on the property, and so they did not tell anybody. They didn't even tell their own agents about it. Their agents, on the other hand, well, first of all, so let's cap off the seller. So the seller was aware of a bunch of stuff, and they did not tell the buyer about any of that stuff. The agents came along, again, not knowing anything that the seller knew about the property, but there were visual clues. So there were things about the property that should have triggered the fact that there was something wrong. They should have recommended soils reports. I mean, there was evidence of slope failure. failures. There was mesh netting along the ground, holding the ground in place. So they had things in there that should have led them to believe that something was wrong. And so this case was held at the lower court in 1978, I believe it was, 77, 78. And then it made its way up to the appellate court. There you go. So they had soil problems in 77, 78. And then this lawsuit got filed. In 76, this lawsuit got filed against the seller of the property, and everybody was held negligent. So again, gives us our standard of care issue, and then the broker appealed the decision, saying we don't have any obligation to do anything. And so this went up to the appellate court, and the appellate court said, yeah, you do. You have it. First of all, the seller has an obligation. And again, I'll send this to you if you want it. Send me an email and say, please send me these things. And I'm more than happy to send these to you. I've highlighted the salient points about it. So the duty of the real estate broker representing the seller to disclose facts includes the affirmative duty to conduct a reasonably competent, diligent inspection of the residential property listed for sale. Does that sound familiar? That sounds like our TDS. We're going to talk about that. And to disclose to prospective purchasers all facts materially affecting the value or desirability of the property that such an investigation would reveal. So that's the standard for the real estate agent. So the seller's duty was to disclose essentially what they knew or should have known, and the agent's duties were to conduct a reasonably competent, diligent visual inspection of the accessible areas. And that's essentially the field case. So, I wanted to touch on that really quick because we're going to spend more time on the forms, but that's the Easton case, not the field case. That's the Easton case. And then we're going to go from Easton, we're going to go to the field case. And the field case was one that came out of our neck of the woods here in San Diego, and that was the case where the brokerage firm represented, in this case, Field was the buyer, obviously, and then the brokerage firm were the defendants and the appellants. They're the ones who appealed the decision of the lower court that found in favor for the buyer and against them. And so the case itself was really a statute of limitations case. The buyer said, I shouldn't be held to 2 years to file the lawsuit, and essentially because there was a breach of fiduciary duty, and that's what you're seeing on the screen in front of you. The issue was that it wasn't so much the finding in the case as much as it was the dicta by the judge. So the judge wrote their opinion on the case, and in that opinion, they were very damning about the real estate agent who didn't even get the preliminary title report until after closing, did not review it with the buyers, made representations about the property that were not true. The property was bigger. They said the property was bigger than it actually turned out to be. There was an easement on the property that they did not disclose. They made a disclosure regarding the easement, but they did not verify anything, and they were negligent in their disclosure. So their disclosure essentially said that the easement was minimal. It wasn't going to impact the property or anything like that. Well, it turns out the easement was by the Otay Water District, and it was much larger than the agent represented, and in fact, that they could essentially dump the tank, which would conceivably flood the subject property, including the residents. And so all those things combined, all of those were held in the preliminary title report. So you need to be good about reading a prelim. But in this case, the agent didn't even get the prelim until after closing. So it was not disclosed. And then it turns out that a bunch of the things that were said by the agent were just factually incorrect. The conclusion here was the fiduciary duty of a broker who contracts to exclusively represent a purchaser of property to investigate for its client is independent of the separate obligation imposed on a seller's broker to conduct a reasonable visual inspection of the marketed property for a buyer's protection, as announced in the Easton case. So anyway, the facts of the case are in here. I've highlighted them. Happy to send this to you. Should be interesting. Okay. So that being said, let's move a little bit further forward. I'm going to say, let's take a look at the TDS. But as you just saw a second ago, I want you to be aware of the fact that this is the commissioner's regulations on disclosures required of a seller, and or if there is one, the real estate broker and the agents. And so this is called the RE6. And so the disclosures upon transfer of residential property, and this breaks it all down for you. Again, I will send this to you if you want it. Send me an email. Be specific about what you're asking me to send. So we're going to talk about some of these things here, like termination right. Think of it in terms of rescission right. And then down here, the transfer disclosure statement and where that came from and all that kind of stuff. So the TDS was actually created after the Easton case. The finding in the Easton case was in 1984, and then the TDS appeared by the legislative body in 1985, and it's been the law of the land ever since. So that being said, let's you can see that I'm scrolling through the commissioner's regulations, and they have an older version of the TDS. We're going to look at the newer version of that in just a second, but I just wanted you to see that this is all the stuff that you see on the CAR form, although the CAR form is much more current than this form is. So just be aware, again, just so the heads up that this is the statement, State of California Department of Real Estate disclosures in real property transactions, and this is their requirement. Okay. All right. So I'm going to close that. And then we also have another sales disclosure chart. This is from the California Association of Realtors. Let me see if I can get this to get a little bit bigger on your screen. There we go. And so this talks about the various disclosures that are required. Again, we're going to differentiate between my statutory and my contractual disclosures. In today's conversation, we're going to talk about the TDS, which is statutory, which says that the law requires it. But then we're going to talk about the SPQ, which is contractual. The SPQA is contractual. The Avid is has become law, and so it is tied to Civil Code 2079. So the TDS is Civil Code 1102.3, and the Avid is Civil Code 2079.13. So good. There you have that. And then let's see, I've got more. I've got my new forms are coming out. I'm very excited about that. I'll be doing a presentation on this next Tuesday. They come out on the week of the 18th of December. So I'll be giving you just the week before they come out. After they come out, I'll be doing all of my templates so that they're all very current. And as you all know, I talk about this all the time about how important it is for you to use the current forms. And so I'm going to, whoops, you can't see that. I'm sorry. Let me take you to what I'm doing right now. Here's where I am. And so I'm going to log into the Zip Forms product because I just want to show you something really quick. When we update the forms, one of the ways that you can tell that we've updated them, and I'm going to pull this down here. I'm going to go to templates. So these are the templates. Everything we do is off of templates. Okay. That way, we know we're doing the same thing and we have a rote business going on. We do the same thing each time, but it also protects us in that we can say we did the same thing for everyone, so discrimination issues are not going to be a challenge for us because we treat everybody equally. We treat everybody fairly. Okay. So when I open up one of these little guys, so I'm going to open up my, well, wait a minute. So, let me just open up the buyer offer template just for laughs and giggles. Over here on the right-hand side, it's not giving you what I'm looking at, so that's not good. Let me see if I can get that to work. There we go. That should do it. There we go. Okay. So over here on the right-hand side up top where it says all forms, that is called my library. Now, if you want to see what forms have been updated, you're going to go to all right here and you're going to go down to form update for 623, but that'll now say in 2 weeks, that'll say 1223, right? And that'll give you all the forms that have been updated since the previous revision, which was in June of 23. Okay. Now, remember, why do we use templates? Because CAR is going to update the library and they'll put all the new forms in there and they'll update all the current forms so that they're all the existing forms so that they're now the current forms. But they will also go into your templates, and in your templates, they will replace older forms with the current forms. They will not add new forms. That's what I do right after the 18th. I'll be in there pounding away on the weekend, updating all of our templates. And so if you have the templates that I've created, then you'll have to send me another reminder after the 18th to send you those new templates. Okay. And so, Joe, you'll get those. I'll get those over to you. But essentially, I go through all my templates and make sure that they're current. Okay. All right. That's why we use templates. And that's part of, risk management, as I say, risk management versus damage control. Okay. So, so those are the new forms that are coming out. I won't go through all of these because that's going to be Tuesday's class, but I wanted you to be aware of it. And then we also have the sales disclosure chart, which I think they did a great job on this. Look at this. Here's all your break your stuff down, agency disclosure. Yes, 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 yes. We pretty much made that a requirement across the board. And so, airport in the vicinity, things like that. So those are the things that we created in the sales disclosure. And then we have the summary chart, which explains things just a little bit more clearer, and then also gives you hyperlinks to the information that you need to have on that. Are there any questions about any of that so far? I just want to make sure, because I'm flying along here. We're going to haul into the TDS pretty quick. Okay, seeing no questions, I'm going to move a couple of things around. Oops, there we go. TDS, so where's SPQ? Good. Okay, back to my, if I can remember how to do this, back to my PowerPoint. So from my PowerPoint, where is it? Here it is. Okay, good. So well, there you go. Let's take a look at the TDS. So let's talk about the real estate transfer disclosure statement and its CAR form TDS. The TDS law took effect in 1985, right after the Easton case, with the addition of disclosures upon transfer of real property, which is the DRE's document, the RE6 that I showed you just a minute ago. Okay, so again, Civil Code 1102, specifically 1102.3. So let's take a look at the TDS itself as it sits right now. And as soon as I get through this, I'm going to show you what we're looking at as far as modifications to the TDS are concerned, because there are going to be some modifications the first of the year, or I'm sorry, December the 18th. We're not going to modify the RPA. The RPA is good. Okay. We're not going to modify the buyer representation agreement. That's good. We're not going to touch it. Okay. So just so you know, don't be looking for changes in that, but I will be doing that class on Tuesday with the new forms. Okay. So this is my real estate transfer disclosure statement. Remember again that this is created by the legislative body. All that CAR has done, and frankly myself, we've gone in and we've taken that TDS and we've put our logos on it, we put our indicia on it, but this is how it is in the current statute. So again, it is California Civil Code 1102. And sequitur here just means and following, means, it's just Latin for and more after that. And please, please, please remember the revision date is going to be June of 23. Make sure that you are using the current form. And so what were the changes on the current form? So the biggest change in this revision, and then we'll talk about last year's revision, but in this revision, that this TDS can be used for a single family detached, or a single family home, let's just call it that, a duplex, a triplex, and a fourplex. So a duplex is the same as like a twin home. It's just that it has one APN number, not two. So in a duplex, one person owns both sides. It's the same physical structure as a twin home, but in a twin home, different people own each side, and they have different APN numbers, different tax base, all that kind of stuff. Okay, so a triplex, usually an income property, a fourplex, usually an income property. And why do they stop there? Well, the reason that they stop there is that California's Civil Code is intended to protect the innocent buyer and seller. And so that's why the TDS says, it's covered by Civil Code 1102, and it's for residential 1 to 4s. And that's what we have here, a single family all the way up to a fourplex. After that, what happens? Well, after that, what happens is the Uniform Commercial Code. So in the 20 years that I've been teaching this, I've wanted to show you this. This is from law school. This is the Uniform Commercial Code. And the pages are yellowed and all that. But this is, and folks, you tell me if you can read that print. I had to read that in law school, and so I'm going to tell you something. It's pretty heavy duty, but that is the Uniform Commercial Code. I mean, I've often wanted to pull that out to show it to people. It's got, you know, mice have been eating on it and all kinds of stuff, but don't tell Linda. But you know, that's the Uniform Commercial Code, and so that's the entire code. Okay, so when I show you this, look, when I show you that, I don't know if you can see that or not, but it's not that big of a thing. And so, you know, and why? Because the civil code is much more detailed. It is there to protect the innocent person, supposedly the innocent person, but at the same time, the Uniform Commercial Code just assumes that, you know, you're in the world of fives and graders, and so they tend to think you're more sophisticated. So that's why they don't need a TDS, you know, things like that. Okay, so all right, so let's dig into this. So this disclosure statement concerns the real property, so I need that top part filled out. Now, when you fill this out in zip forms, it should fill this out for you. Okay, but the next one I find, you know, I'm also looking for, you know, what items are most frequently missed. And so right here, the date. Okay, so frequently I see that not to be filled out. But it has to be, otherwise it's an incomplete TDS, otherwise known as a defective TDS. And if you remember from when you got your real estate license, the buyer has 2 years to sue on a defective TDS. Okay, so the date needs to go in there. This top part is stuff that the agent can fill out, or you can have the seller fill out the date field, but it should be the date that the seller completes it. So as of this date, this is what, you know, is going to follow. Okay, then I get into section 1, which is coordination with other disclosures. And so this part has changed. So what was going on before was we had only the first two, inspection reports and additional reports. Well, we chose to have added, the legislative body added no substituted disclosures for this transfer, and the italics is their doing. Okay, so the italics are there in place. Okay, and so when you're looking at the transaction, and again, you don't have the ability to fill this out on behalf of the seller, and I would tell you not to go to means. I've seen people do it where they go to extremes where they can fill it out for the seller. That's going to be a potential license loser. I can tell you that I've been in court with this type of scenario, and back in the day when we were filling them out online for the sellers, and then in court, the attorney plaintiff's counsel would ask the seller, "Is this your disclosure?" And they would say no, and they say, "Well, so who filled this out?" And they would say, "Well, the agent did," and then they just had me sign it. So now you and I might argue the fact that, you know, you signed it saying that you filled it out, so you must have read it, but that's not how it's going to go in court. Okay, so anyway, so we've made it so that from 1 down on pages 1 and 2, you, the real estate agent, can't change anything. Okay, so let's take a look. I want to show you, there is a quick guide to this section. So the substituted disclosure section, this is a quick guide by the California Association of Realtors. And again, I show you these things because I think they're really, really important, but unfortunately they get kind of buried in all the stuff that we do. I mean, CAR does a lot of stuff for its members, but again, they're paying people to do it. And when they finish that task, they check the box and they move on to the next thing. And then we forget to tell you where it is. Okay, so that's very, very important. So why was it added? When and why do you check the boxes? What is a substituted disclosure? You know, and then so we have all these things. So again, I will send this to you, but I'm going to tell you that as a matter of principle, the chances are that the seller is going to check this third box. But again, they need to read the Q&A. Give it to your client, have your client read it. We have it in our template so that the client will be aware of that. Okay, all right. Anybody have any questions on that part? And then I'm going to go into section number 2. Okay, all right. So section number 2. So section number 1 was coordination with other disclosure forms. Section number 2 is seller's information. And so from in here, the seller is going to let us know whether or not, oh, by the way, the following representations made by the seller and are not the representations of the agent, if any, if there are any agents there, okay? It is a disclosure not intended to be part of any contract between the buyer and the seller. So they're not a contract, but they are referred to in the contract, okay? So is the seller not occupying the property? Paragraph number A the property has the items checked below. So I always tell my seller that, listen, if you're going to take the microwave with you, then don't check the box. Take the microwave with you. Make sure you make a notation that the microwave is not included so that everybody is aware of that, okay? And then they go down through the list. They check those items that are included with the sale. And then down at the bottom, they're going to be asked the question, are any of the above, not in operating condition? So I always set the seller up before you check the box. Realize that anything up there that you check, that if it's not in operating condition, take it with you, or prepare to have to answer the question, can you explain that to us? So which one is it? Okay. All right. So again, the TDS is put together by the statutory body, and the only licensee I'm aware of is Brian Jones, who is the head of the minority in Sacramento. And he's got a real estate license. He's the only one I know that has a real estate license. Maybe others have it as well, but that's just kind of where we are at this moment. Okay, everybody good? So any questions about filling out this part of section number 2? When we get down here, yes, I need to have all this filled out as well. And as for risk management purposes, I'm going to be checking. This is the first thing I check on this page is, well, A, did they check anything up in section 1, any of the 3, but then down here, yes, no. If they checked yes, I'm looking for an explanation. If they check no, then we're going to move forward. If they didn't check anything at all, then I'm probably going to send it back to the seller's agent and say, do you want the seller to complete the TDS because they missed something and maybe they want to get that fixed? Okay. All right. Everybody good? Going to page 2. So on page 2, we're going to start up at the top. I'm going to make sure the date is there, obviously, and the address is there. Paragraph number B, are you seller aware? And the operative word here is aware. And we're going to see this theme carry out throughout this document, but we're also going to see it on the SPQ and the SPQA. So are you aware? So let's think about this for a second. Are you aware? If the answer is yes, then you check the box that says yes. If the answer is no, then you check the box that says no. All right, I know that sounds obvious, but what happens if you don't know? Well, then the answer is no, right? Because I don't know, no satisfies I don't know, right? So there is no place for you to add in there, I don't know. Although I used to see people try to add right in, I don't know. And it's like, you know what? First of all, you can't do it today. Most people are doing it when they printed the form. But, if you're either aware of it or you're not. So if you're aware of it, check yes. If you're not aware, and that includes I don't know, then check no. Everybody good? Question. Okay, got one already. Good, hot one. Rachel, how do you have clients complete these forms? Okay, good. So when you send the client these forms through the zip forms process, so let me pull up my program again here. I'm going to go to the seller listing template. Good question, Rachel. So I'm going to go in here. I'm going to click on TDS. And there's my TDS. So when I send this out for signature, well, let's pull it up, and then that'll make it a little bit easier to understand. So so you see up here, this is the part I can actually fill out. But when I get down here, it's in a color. I think I might have changed the colors, but this is the part the seller is going to have to fill out. So when I send this for signature, whether you're sending it out through zip forms or Glide, whatever your signature platform, DigiSign, AuthentiSign, it's AuthentiSign. When you send that out for signature, you first of all, you can't complete the form here. See, I click on it and I can't see editable by seller 1 down here in the corner. I can't complete anything. Okay, so when it goes to the seller, though, now they can complete it. And this is why I said earlier, you got to go to heroic efforts to try to, alter that and make it so that you can fill it out. That I wouldn't be doing that. You're going to get yourself into a ton of trouble. Okay, so this goes to the seller for signature. Now, in the Glide program, you're actually able to be online with the seller as they were completing it and coach them through the process. In zip forms, it doesn't do that. But however, we can pull up, I usually pull up a screen, a screen share, Google Meet, Microsoft Teams, things like that. I can pull up a screen share and guide the seller through it. Because remember, our job is to advise and counsel, not dump it on them or have the TC send it. I'm going to tell you that's a very bad defense. I had the TC send it. Well, did you go through it with the seller and counsel them on how to fill it out? Well, no, I just had the TC send it. I told them if they had any questions, just let me know. Folks, that is a losing defense. Okay, so hopefully, Rachel, I've answered your question on that. How do you have them completed? I just send it out for electronic signature, and then these fields for them become editable. Okay, that doesn't mean that you can eat them. That just means that they're able for them to edit. Okay, everybody good? Seller then initials, here on page 1. The initial, by the way, does not create the agreement or the contract or even the disclosure. It just allows you to have evidence of the fact that they saw it when they filled it out. Okay, now I'm always going through here looking for stuff that they missed, and that's whenever I'm representing the seller. Okay, when I'm representing the buyer, I'm looking for stuff that may be important, and I'm going to send it back to the seller's agent to see if they want to complete it. Okay. All right. Page 2. Thank you. That was a great question. Thank you, Rachel. Let me take you back to the document. In the PDF, it's a little easier for me to work with. I can highlight it. The other program doesn't let you highlight it. Page 2, are you, seller, aware of any significant defects or malfunctions in any of the following? And so over here, yes or no. And so what do we say? Yes, you're aware, or no, I'm not aware. Well, I don't know is also part of no. So if you're not aware, then the answer is no. Okay. So, and that's your safety hook. You don't need anything else than that. And if you put in yes, I'm going to be looking for some explanations down here, or I'm going to ask you to check these boxes as to which one may apply. So like a cracked slab, for example, where is it? Right here. Check the box that says slab. Okay, so, whatever it is, if you answered yes, check the box and then explain it. And then if you got to go to additional sheets, do that too. We're good with that. Okay, but I need an explanation. Do you need to go to heroic efforts? The chances are pretty much you don't. But as the seller, I would probably put as much in there as I needed to put in there to make sure that I can at least defend the fact that I made the disclosure. Okay, all right. Okay. Pre-printed language here talks about my carbon monoxide. So this is why I don't need a carbon monoxide form. Garage door openers, child resistant pool barriers, things like that. I don't need the forms for these because it's all covered up here. Okay. All right. Water conserving plumbing fixtures after January of 17. And so, most of us are doing the WCMD form anyway, but fixtures in the dwelling may not comply with 1101.4 of the Civil Code. Paragraph number C, I can tell you in my experience, I rarely see it completed properly. We added the word to C1, we added the word mold probably 20 or so years ago, because people were answering no. So what the seller does is the seller draws a line all the way down here and says, no, I'm not aware of anything. I don't have any problems with property, none of that kind of stuff. There is no way that you can answer no to all of those things. Okay, there's no way, you can't do it. So when we did number 1, we added mold, and mold is everywhere, right? And so I even tell my sellers, the seller says, well, I don't have any of those things. You don't have mold? Well, no, I don't have any mold. Okay, well, how about the shower? Okay, all right, I got mold in the shower. Okay, so mold. All right, so mold causes you to say yes. And then down here on the bottom, you fill out, where the mold is or whatever to explain it. Okay, and so most of my sellers say mold is everywhere. It's part of the life process, chlorophyll A, chlorophyll B, photosynthesis, whatever. I mean, we're taking it seriously, but it's really hard for you to answer number 1, no. Okay, number 2, features of the property shared in common. How do you say no to that? Most times you have a wall. Whose responsibility is it to maintain the wall? Or we have fences, driveways, other things that may have an impact. Features shared in common. You're in a condominium. You've got common walls. So the answer is going to have to be yes. And I'm going to have to explain it down further at the bottom. Encroachments, easements, or similar matters. Now, me personally, encroachment is something obviously that trespasses on the property. So like a tree hanging over, or roots underneath the ground, or stuff that water even had a lawsuit over water where the neighbor's property was up a little bit higher than the subject property, and they were flooding their lawn, and this is in La Jolla, flooding their lawn in order to get saturation to get the lawn to grow, and the water is going under the fence and flooding the neighbor as well. So that, I think that's an encroachment, right? Okay. Easements, all properties have easements, right? Utilities, whatever. Paragraph number 4, room additions. Now, this one you may be able to get away with the seller may be able to get away with a no. So any of these things done without permits. So if you have that no permit situation, and I have a lot of those where the sellers were doing things without getting the appropriate permits done from the county. So the answer is yes or no. 5 says that whether you had the permits done or not, was anything done not in compliance with building codes. Okay. And then 6, remember our conversation this morning on the Easton case. The Easton property was built on fill. So we have cut, we have fill. And so number 6 talks about fill, whether it was compacted or not. And in the Easton case, we had fill that was not compacted properly. And so as a result, that's the part that went away. I had the lawsuit where the cracks were noted in the bedroom, and then the agent made the mistake of putting in, minor settling cracks. And then, after closing, of course, the bedroom broke away from the rest of the house because it wasn't minor settling. That part of the house the rest of the house was on cuts. They'd cut into the side of the hill, but this part of it was on fill. They brought in dirt, but they hadn't compacted it properly. Okay, so make sure you're going over this with your seller. Don't just blow this off, all right? Any settling from any cause or slippage, sliding, or other soil problems, right straight out of the Easton case, okay? Flooding, drainage, or grading problems, all right? Again, same kind of scenario. I find that a lot of times we build our planter boxes along the side of the house, and we trap the water in between the house and the planter box, and my experience has been that it causes the concrete to decay, and then that's where we get our efflorescence from, and that's where we get some issues with the slab failure. Okay, so I always tell people, don't plant a bunch of stuff around this, contiguous with the property, with the house itself, but people do it. So what are you going to do? Let's see here. Major damage, number 9, major damage to property or any of the structures from fire, earthquake, flood, or landslide. That comes out of the natural hazard. Any zoning violations, non-conforming use. A non-conforming use is a use that was legal at one point, but after it was in use, the law changed around it, and it would no longer be a legal use, but they're grandfathered in. That's my non-conforming use. And then violations of setback requirements. The property's supposed to be 6 feet away from the property line, but it's only 4 feet away from the property line. Those are the kinds of things the seller needs to disclose if they're aware of those things. Neighborhood noise problems or other nuisances. So, where I live in Del Mar, I'm right on the right on coastal. The train goes right by in front of my house. The helicopters come right by the front of my house. I always say, if I can read the call sign on your helmet, you're too close. But do I have to disclose those things? So when I first moved into the house, the rumble from the train was amazing, and it's right next to the bedroom, and so it was a pretty scary thing. Well, of course, over time, I've gotten to a point where I just come to accept it, but I've also come to kind of tune it out. And so as a result, I need to remember to say that to the buyer when I go to sell the property, to the buyer that, hey, by the way, the trains go right by in front. The helicopters, the Marines are great pilots, but in the summertime, their eyesight is worse than in the wintertime. They're always right up on the beach looking down, versus in the winter, they're a mile out to sea, that kind of thing. Figure out why that is. And so that would be an example of a neighborhood noise problem. How about a ballpark next door, or a church parking lot, or barking dogs, things like that? Those are going to be neighborhood noise problems. Excuse me. Other nuisances might be characterized as noxious odors or something like that. Okay. Paragraph number 12, CC&Rs or other deed restrictions or obligations. My sellers always check that box because that doesn't say any homeowners association. That comes in number 13. But in number 12, all properties have restrictions on them. I'm not allowed to build a 13-story high-rise on my property in Del Mar. I assure you, everybody would be coming down to visit me if I try to do that. So I do have deed restrictions on the property. And so number 12, I'm going to have to check yes when I sell the property. So number 13, is there an HOA? I can say no to that because there is no HOA, but don't just assume. So usually anytime you have a common area like a fence or a swimming pool or a tennis court or a guard entry, anything like that, you probably have an HOA involved in that. Okay. So you talk to your seller about that and make sure that they hit the right box. don't leave any boxes unchecked. You need to check all the boxes. If they leave a box unchecked, that means they had a question that they didn't ask you. They need to go back and they need to fix that. Otherwise, you're going to have to resend them the form. Okay. All right. Common area. We talked about that. Facilities like pools, tennis courts, walkways, etc. 15, any notices of abatement or citations against the property. You've let the weeds grow to the heavens on the property. You're probably going to get a notice of abatement. The fire department will stop by and say, here's a notice of abatement, fix the weed problem, get it cut down. Or we'll cut it down for you. And then you don't do it. And then they come by and then they issue the citation, which says, here's your $500 ticket or whatever it is. And if you don't do it, we'll cut it for you. And by the way, they can foreclose on your house with that. So you have to, number 15, you have to know what those mean. And you have to ask the seller if any of those apply. 16, any lawsuits, pretty obvious. And then you're going to, if it's yes, then explain it. D is kind of good because it certifies the property is in compliance for smoke detectors, smoke alarms, we call them actually, carbon monoxide detector and smoke alarm. And so this says that it is in compliance. Doesn't mean the seller had to do it. It just means the seller is certifying that it was in compliance when they completed all this. Number 2, D2 says the same holds true about the water heater. That's why I don't need a separate smoke detector water heater statement of compliance, because it is covered on the bottom of page 2. Everybody good so far? Going on to page 3. So remember, page 1 and 2 belongs to the seller. Page 3 belongs to us. So page 3, section 3 is going to be the agent's inspection disclosure. So in the old days, we never had the Avid form, okay? By the way, the language above it, based on a reasonably competent, diligent visual inspection. Does that sound like the Easton case? Straight out of Easton, okay? All right. Underneath that, the Avid, that's what everybody does. We're all doing that. And the district manager for the Department of Real Estate said, we love the Avid because it gives you an opportunity to document the fact that you actually went out and did the Avid. So the number 2, notes no items for disclosure. As I said this morning, Pete Selecki, the former JAG, by the way, the attorney for the company I was working with, the Rock People, and now the counsel for SDAR, said, you check that box, agent notes no items for disclosure, and I will go out with you to the property and we will come up with all kinds of stuff. Okay. The old way, we had a box to check, agent notes the following items, but we found that it wasn't enough to jog the memory of the agent, much like the SPQ jogs the memory of the seller. So we check agent's visual inspection disclosure form, which we're going to talk about obviously a little bit later on. The seller's agent signs it. This is important. Why? Because remember that the TDS is not considered to be complete until the buyer gets it, and the buyer also gets the seller's agent's Avid. Okay, so TDS is not complete until the buyer gets the seller's agent's Avid. Is everybody good with that? So that means this part checked and signed, and then the Avid is done and also given over to the buyer. Okay. All right. So section number 4 is when we get into the buyer's agent, if there is one. If there isn't one, if it's the same person, then there's no reason to fill it out any more than that. You've done everything above. Okay. So if other than the agent above. Okay. So if there is a buyer's agent, here we go again, reasonably competent, diligent, visual inspection, et cetera, et cetera. And then they check whatever box their broker tells them to check. And then they fill out their information down here on the bottom of the form. Now, in the past, and I think we've fixed it now, the electronic signature platforms were having the seller sign this before the buyer's agent filled in their part. And so you don't want that, okay? Because why? Because this says that they've got a copy of what's above. And if they sign this down here before this is filled out, then obviously they don't have a copy of what it's above. And technically speaking, the buyer's agent is committing fraud by altering a document over a signature, okay? All right, so down here, remember when the signatures are next to each other, it doesn't matter who signs first. When they're on top of each other, then they are done in chronological order. So here, after the buyer's agent has completed this, normally they send it to their buyer, who's going to sign over here, and then it comes back to the seller's agent, who will then have the seller sign here, and then the agent sign. Although at this point, I'm probably going to be looking for counter signatures, but clearly not before the buyer's agent fills in their section number 4. Everybody good? Questions about any of that? Seeing none. Down here at the bottom, 1102.3 provides a buyer the right to rescind. A very powerful word in law, says put the parties back in the position that they were in prior to contract. Okay, so gives the buyer the right to cancel, to rescind the contract 3 days after delivery of this disclosure if delivery occurs after the signing of an offer to purchase. So what does that mean? That means that when I get an offer on a property, I have the seller fill this all out before the offer ever came in. We sat, right, Joe? We sat down with the seller. We spent 3.5 hours going over the disclosures with them. And then when the offer came in, we just shot it all over to the buyer through the buyer's agent, all the disclosures. Buyer has everything they need to make the decision. They have no statutory right to rescind the contract. Okay, so again, legal decision, check with your broker, check with your attorney, but if you get them all the disclosures at the time of the offer, then they can't rescind the contract. They may have other contractual ways out of the transaction, but they won't be able to rescind. Okay, and so again, if you wish to rescind the contract, you must act within the prescribed period. But again, if you get it all before the contract, you don't have the 3 days. Everybody good with that? Questions? Seeing none, one of my favorite forms. So I did tell you that this is my substitute. I'm going to close the substitute disclosure because you know about that. But then I have my silent revisions. So these are what are going to be revised in the TDS. Actually, I've gone through this and I didn't find anything in red. So I'd have to read it pretty thoroughly to figure out what they changed. But I know that they are doing a change to the TDS that'll take effect at the end of this year, but it'll have to do with flippers. So people that it's what's called a nominational addition to the contract. I can't remember the name for it, but I don't see it in here. But essentially, it has to do with people that are flipping property who think that they are exempt from the TDS. Remember, even if a seller is exempt, it all that means is that they don't have to use the form. They still have to make the disclosures. Okay. And again, I'm flying through this pretty quick and I don't see where that change would have been. I got 16 paragraphs. That's about right. So I'm not seeing anything that addresses flippers, but that's what I was told by Neil Kalin was what was coming with the new TDS, and it's like one line. It's a nominal, I think he said a nominal addition to the contract. And again, I don't see where it is in here. So I brought it up here just so that I could mention it to you. But again, I don't see what reference they're referring to. Everybody good? Anybody have any questions on the TDS? Seeing none, I'm going to close us out on the TDS, and then I'm going to take us back to PowerPoint. So again, the TDS took effect in 1985, along with the RE6. California law requires that sellers disclose to buyers any material facts known to the seller affecting the value or desirability of the real estate of the property, right? This includes the duty to amend. So how are we going to address that? So duty to amend. So the seller completes the TDS, gives it over to the buyer. After the seller has done that, now all of a sudden there comes up the issue of the let's see here if I can pull it up really fast for you. Nope, I don't have it in there. So something happens. So for example, seller completes the TDS, and maybe I can do it with addendum. ADD. Nope. I thought for sure I had it in there. Okay, all right. So I don't have it in there. I'm going to pull it up. All right. So anyway, the seller completes the TDS, and then something happens. So again, I want the seller completing the TDS at the time of the listing. All right. But let's say 2 weeks later, you've given the buyer the TDS, they've signed off on it, and then 2 weeks later, the police chase the bad guy into the property, shoot and kill him dead. What does that do? Well, that's going to be a Civil Code 1710 amendment, a requirement to amend the TDS. So let's take a look at that amendment form. So here it is. This is my addendum. Notice there's a box right here, transfer disclosure statement. So this is an addendum to the TDS. Okay, this can be used as an addendum. An amendment to the TDS, now see, now they're going to change their mind. Is it an amendment or is it an addendum? Remember, an addendum adds to the contract, an amendment changes the contract, and those are two different things. And they fixed most of this, which is good. But and again, my hat is off to the attorneys at CAR. They're just amazing stuff, and this is what they do every single day. Okay, so an amendment to the TDS may give the buyer a right to rescind. So again, police chase the bad guy into the property, shoot and kill him dead. Now we have a death on the property. So does the seller have to disclose the death? And the answer is yes. And then this would be the appropriate way to do that. Again, statutory requirement. But then now the seller may, they may have triggered that right of the buyer to rescind the contract. Everybody okay with that? So use it sparingly. Make sure you check with your broker before you do it. But that does include the duty to amend. Okay, so remember that you may not waive a statutory right, which means we all can't agree that we won't require the TDS in a transaction. That is just against public policy. Okay. All right. So since the TDS is statutory, it may not be waived. And that's kind of the basis of what I'm trying to say. That includes attempting to contract around it. People try to write things up, say, we're going to waive our right to it, all that kind of stuff. Okay. All right. Remember, the TDS belongs to the seller. Okay. Pages 1 and 2. All right. Not the agent. You do not want to be filling it out on behalf of the seller. Seller completes the disclosures on pages 1 and 2 with the advice and counsel of the agent. Okay. Section 1 has changed. I showed you that. Note the substituted disclosures. The top of page 1, very important. We rarely see it completed properly. Section 2, rarely complete. Incomplete TDS risks a defective disclosure, a lawsuit for a defective disclosure. Okay. All right. Buyer has 2 years to sue on a defective disclosure. It's a state exam question. All right. Section number 2C, almost never completed properly. Again, I already showed you that part. Paragraph number 3, which really should say section number 3, not paragraph, is the agent's visual inspection disclosure. And the TDS, again, is incomplete until the seller's agent's Avid is given to the buyer, delivered to the buyer. Okay. Everybody good? And then on paragraph number 4, which is the buyer's agent's visual inspection disclosure, after that, the parties and the agents sign, but not until the buyer's agent fills out paragraph number 4. After all the above are complete, that's when the rest of the parties sign everything. And remember, you're not the party, you're the agent. The parties are the buyer and the seller, and they're just acknowledging receipt of the completed form. Okay. All right. Remember the discussion at the bottom of page 3, and I just showed you that was the statutory right to rescind, assuming that that the TDS is given to the buyer after the contract comes together. Okay. All right. We good? Okay. Let's take a look at my SPQ. Seller property questionnaire is CAR form SPQ. It is a contractual obligation, not a statutory obligation. So, but I'm going to tell you, it is incredibly important. It is intended to decode those items that the TDS missed. Okay. It is also the standard of practice in California. So let's pull up the SPQ really quick. I'm going to go to my PDF portion of things. I'm going to get rid, here it is, my SPQ. So again, make sure you're using the current form revised on 6/23. It says right up here, this is not a substitute for the TDS. It's used by the seller to when a TDS is completed to provide additional information. If the seller is exempt from completing a TDS, then they should complete the exempt seller disclosure. So let's take a look at that exempt seller disclosure. I want to pull that up really fast. So I'm going to back out of this one right here. No, I don't want to change anything. And then I'm back to here. Okay, so my ESD is my exempt seller disclosure. So let's go ahead and add that in here. I don't have it in there yet, so that's a little bit of an irritant, but okay. So there's my exempt seller disclosure. I'm going to go ahead and add it just in case, again, this is our listing template. So just in case I get a seller who is TDS exempt, there are still statutory disclosures that they needed to make. And so here's my, for use by sellers who are exempt from completing the form, the TDS, or for any seller who does not provide an SPQ, they do this one. Okay, why? Because the TDS does not contain, look down here on paragraph number 3. These are the statutory disclosures that the TDS does not address. So TDS is incomplete. right? They just don't want to add to it. So we created the exempt seller disclosure where the seller is TDS exempt, but we'll see in a second when I get to the seller property questionnaire, all of these questions are on that form because we still need to have the seller answer those questions. Everybody okay? So again, fairly simple. Within the last 3 years, death of an occupant of the property, upon the property, methamphetamine, that's also a statutory requirement, release of an illegal controlled substance on or beneath the property, whether property is located in or adjacent to an industrial zone, whether it's affected by a nuisance created by these are all statutory disclosures, okay? So notice ordinance is there's no I in ordinance. So some of us here, if you've been military, then ordinance is stuff that goes boom. They were just firing off the 200-pound guns at Quantico yesterday. I'm telling you, everything shook. It was just amazing. That's just boom, right? So that is ordinance, stuff that goes boom. So Coronado, Tierra Santa, stuff like that. If it's got an I in it, then that means it's a local rule or a regulation, okay? All right. Let's see, insurance claims affecting the property within the last 5 years, plumbing fixtures that are not compliant, or any other material facts that you haven't disclosed. And that's my ESD. That's my exempt seller disclosure. Okay, so let's go ahead back to our SPQ, and so we'll go here and cover some of the things on the SPQ. And so this pretty much tells the seller a lot of what they were told before, but once again, we added this property is a duplex, triplex, or fourplex, just like we had in the TDS, and then we start getting into some of this. So my advice to you, my non-legal advice is I would read this. I mean, if you've had a real estate license for more than 6 months, why haven't you read this? Okay, so you need to look at what this says, okay? The disclosure statement is not a warranty of any kind by the seller or the agents and is not a substitute for inspections or warranties the principal may wish to obtain. And so these are things that nobody cares about, nobody reads until you're going to court. And then when you're going to court, of course, the attorneys blow this up on the screen, 10-inch letters so the jury can see it. So these are the kinds of things that you want to make sure that you have read, but at the same time that you want to make sure that your client has read. Everybody okay with that? Paragraph number 2 explains known material or significant items, explains to them how to answer it based on actual knowledge and recollection at this time. Note to buyer, the purpose is to tell you about these things. Paragraph number 4, this is again the state of California. This is the standard of practice in California. Seller's awareness. Here we have for the first time an explanation of what that means. Are you seller aware? So by checking either yes or no, right? A yes answer is appropriate no matter how long ago the item being asked about happened or was documented. And then of course, no means I don't know or I'm not aware. I just don't know. Okay. All right. And then paragraph number 5 talks about documents, additional documents that you would provide. And again, when we look at the SPQA, we're going to see some of these things are embellished even further in San Diego County. Okay. And then ultimately CAR will copy them or do whatever. Again, remember your SPQ came out of San Diego. It was the seller's additional disclosures form. And the attorneys at CAR said, wow, we really like that form. We don't have such a state form. So they created the SPQ. So when they created the SPQ, they deleted our SAD form. And so we created the SPQA so that it would be known as an addendum to the state's SPQ that was particular to San Diego County. Okay. All right. And again, it's not covered by the user protection agreement. Only the SPQ is. Okay. All right. So here's my disclosures. Within the last 3 years, the death of an occupant of the property upon the property. So these are the things that you just saw in the exempt seller disclosure. Here's my state ordinance, right? Same thing you just saw in the seller's exempt seller disclosure form. And here they are, insurance claims affecting the property within the past 5 years, et cetera, et cetera. So remember, if your seller is TDS exempt, and remember that's a legal decision. Okay. So I've had quite a few transactions recently where the agents said that the seller was TDS exempt. And so, I'm constantly sending emails trying to get proof of that. and they just don't understand it. They said, well, we sent you the exempt seller disclosure. It's like, well, all that says is that the seller is claiming that position. It doesn't say that the seller is actually TDS exempt. That's going to require a court order, an attorney's opinion, something like that. So they're not going to get it. I'm just going to keep sending questions and keep on asking them to provide those forms, knowing that they're probably going to continue to say no. And if they do continue to say no, I'm going to be able to at least document the fact that I asked for it, because I might have to protect myself from my own buyer. And so, by the third time I ask for this, and they say, no, we're exempt, then I'm going to have the buyer sign a blank form, and then I'll put that in the file along with the buyer's initials or signatures on the email request that I was doing that says, look, I showed you that I've been trying to get that. They're refusing to give it to me. At least I can protect myself, perhaps from my own buyer, because remember, it's the buyer who sues. Okay. Questions on any of that? Okay, paragraph number 7 talks about repairs and alterations. Again, breaking down the TDS even further, structural systems and appliances, disaster relief, insurance or civil settlement, and then water related and mold issues, pets, animals, and pests. So again, we're drilling in, we're trying to jog the seller's memory about stuff about the property. Here I've got my boundaries, access, and property use by others. I've always said that property boundaries, fences make good neighbors, but they make lousy property boundaries. So don't assume that where the fence is the property boundary. But I get it all the time. I get, people say, well, I asked the agent, how far back does the property go? He said it goes back there to the fence. Well, I had that case where there were 2 properties before you got to the fence. And so nobody knew about that until, of course, the buyer says I didn't read the PR and the agent didn't explain it to me. And so, I get to sue everybody. So landscaping, pool and spa, condominiums, common interest developments, and other subdivisions, if applicable, title, ownership, liens, and legal claims, if any. Okay, neighbors and neighborhood. I always tell the buyer to go to the property. When do you sleep? Well, I'm there at home at night. I work a regular 9 to 5, Monday through Friday. And then, so when do you need it to be quiet? Well, I need it to be quiet at 10 o'clock at night. So go park out in front of the property at 10 o'clock at night or whatever, and just see, is there anything going on there that's going to create a problem for you? So you always want to have that conversation with the buyer. Okay. Governmental stuff, if anything, condemnation, stuff like that. And then any occupant of the property smoking or vaping any substance on the property, whether past or present, things like that. And then if additional items, then go ahead and check the box and provide those on another form. And then the seller makes their own representations here, and then the buyer signs it. And that's my SPQ. Okay, and so I love the SPQ. I had a lawsuit where I'm trying to remember which one it was. The paragraph had to do with the community doing things. The HOA was doing stuff. Let me see here. See if I can find the paragraph. Great big law. Oh, here we go. Under 14. So this great big lawsuit. Let's see if authority made improvements, and or I'm spending too much time looking at it, but so essentially it was a paragraph that said that the HOA has ongoing maintenance on the property, and they're essentially reminded as a property up in Orange County. Essentially, they're redoing the entire property. Okay, so I think that's going to fall under E. I thought it was F. And so without the required proof. Okay, so F. So the seller in this situation, we represented the seller. The seller did not answer F, 14F. And there was ongoing construction going on. They were doing the whole place up. Buyers from New York, by the way, although the buyer had seen the property. But they could, how do you miss it, right? They got contractors and trucks and stuff. So the seller didn't check the box. So the seller later on, the buyer comes back and says, do you want to have the seller check 14F, because it's obvious that there is stuff. Now this is an admission from the buyer's agent. So the seller then did check the box, and we sent that back fixed 2 weeks before escrow closed. 2 years later, the buyer files a lawsuit against the seller saying that they were withholding information. The seller says, like, how? And they said, well, you sent us the SPQ without that box being checked. And the seller's response was, well, yeah, but then I fixed it and I checked it, and then you got it weeks before you could have made your decision not to move forward. And so the buyer said, well, we really feel like, I mean, it was one of those feel, felt, found things. So we really feel like you were withholding stuff. So anyway, it gets all the way to court. And needless to say, the judge said, you know what, it was fixed prior to closing. You're on your own. Turns out later on, of course, the buyer had a real estate license in New York, which wasn't disclosed and stuff like that. So, so make sure that the seller completes the form, and then make sure that they return the form completed. Check all of these boxes to make sure that they've been complied with. And if it's one of those things that says, if yes, then explain further. Well, obviously, if they said no, there's no reason to explain anything further. Is everybody good with that? I want to make sure we covered that. It is the standard of practice in California. So are you, seller, aware of, and again, aware of, it mirrors the language in the transfer disclosure statement, okay? So let's take a look at my SPQA, and I really like my SPQA. I think it's a great form, and it kind of rounds out the house. So let's take a look. I'm going to go back over here to the SPQA. I should show you, here's the draft of the new SPQ coming out. So let me see. I think there's like one change in the entire form. So help me out here. Do you see anything? Oh, there we go. So whether any structure on the property is an ADU, so we added that language to it. That's the one change coming to the SPQ that I thought you should be aware of. Whether the property was originally constructed as a manufactured or mobile home. And again, my hat is off to the California Association of Realtors for adding these things in there. Great job on that. So those are my changes to my SPQ form. Then we get into my SPQA form, and I really like the SPQA. I think I've already told you that, but again, created by the Greater San Diego Association of Realtors, intended for use primarily in San Diego County, and it is not covered by CAR's user protection agreement. So the simple recitals up at the top, and then down here it says the form is for use with the SPQ. It must not be used without the SPQ. And I get people all the time, they say, I've got the SPQ. I don't need the SPQA. And then I just had a transaction where the seller's agent said, we're not going to give you the SPQ. Well, they were angry because they weren't members of San Diego. So, they were angry that we had a form and they didn't want to provide the SPQA. And so, we're going to be on record for asking for it, and they're going to be on record for refusing it. So the headings below duplicate those of the SPQ, so that we can just compare them apples and apples. It is urged, and this is good, that the two forms be placed side by side, and the questions under the same heading be completed on both forms at the same time, okay? Paragraphs below are numbered to assist you in comparing it to the SPQ. If you don't understand how to answer the question or what to disclose in response to the question, you should consult a real estate attorney in California of your choosing. Again, I think well written. Broker cannot answer the questions for you or advise you of the legal sufficiency. And so much like Rachel, your question earlier, the TDS goes out for signature and completion by the seller. SPQ does the same thing. SPQA does the same thing. So all three of these forms, you may not fill them out online. They will all go to the seller to fill out. I would pull up a screen share of some kind and go over it with the seller. I don't think it's that complicated to do. If you don't know how to do it, I say that I'll help you. Okay, I want you to be okay, whether you're using Zoom or Google Meet or Microsoft Teams. I did a presentation for the Department of Real Estate. They said we don't use Zoom, right? It's dangerous for the presenter, like me in this case, right? So I prefer Google Meet. I do a lot of Google Meet. I have people who with other brokerages who ask me a question about something. I say, well, I'm going to invite you to this. Let's do a screen share, show me what you're doing, or I'll show you, where you should be reading and to help you out with that. Okay. So I won't get in front of your broker, but I do want to make sure that you're taken care of. All right. So here where it says SPQ5, this is relative to the seller property questionnaire, question number 5. And so this goes a little bit deeper into seller's awareness. Okay. This is SPQ6. We don't have anything to talk about. Right? Look at that. Look, SPQ6 on the SPQ form did the job. They finished it. It's okay. We don't need to comment on it. 7, we just thought, okay, well, let's attach a copy because that wasn't in the SPQ on paragraph number 7. Here's number 8. We thought that number 8, we needed to kind of drill into this a little bit farther. And in fact, didn't we just see a change? Not on this part. Shoot, I should not have closed it, but I did. Okay. Are you aware of hardwood floors, et cetera, et cetera? Then I get down to page 2, and I'm looking at leased or liened items and systems, which was not addressed in the SPQ. I'm going to bet that at some point later on in the future, they will address it. But again, you know, for the broker that called me this morning about the solar panels, is the solar form, CAR solar form, statutory requirement that triggers the right of rescission? The answer is no, but it may trigger material facts affecting the value and desirability of the property. But look here, I got my photovoltaic panels, those great big things up on the roof of the house, right? The things that I always say, how could you possibly miss that? And then anything that's got a UCC filing on it. So our solar panels tend to be not showing up. And I had a broker tell me they would be in the preliminary title report. And I said, no, they're not. They're never in the prelim. And they weren't. They weren't in the prelim. You know, they're a UCC filing. Okay, so remember UCC? Remember my uniform commercial code? Okay, all right. Okay. All right. So, you know, what are the monthly payments, et cetera, et cetera, et cetera. Now, by the way, I have a lot of times the sellers will say that the solar is paid off. Well, that may be a true statement, but is there a maintenance contract on it that is still in place? Because a lot of times what they'll do is you'll pay the solar off, the solar power system off, but you won't have there's a maintenance agreement that you have to continue to make payments on. So make sure that disclosure is made to the buyer that there is a maintenance agreement, and if they want the maintenance agreement to apply, they're going to have to continue to make the payments on it. Okay. All right. Question. Hi, Anonymous. Welcome back. Where can the SPQA be obtained? So the easiest place to do it, and I'm going to go ahead and log into my zip forms, wherever that is. That's PDF, that's PowerPoint. Where did it go? Is it this one? Yeah, there we go. Okay. So when I go into my form, now I'm in my seller's listing template, but this is in a transaction. I go over here to all forms on the right. Everybody see that okay? See right here where it says California Association of Realtors. I'm going to click on the drop down and I see San Diego risk management forms. Okay. Now yours may appear at the bottom. It may appear someplace else on that part of it. But, you know, again, when I teach how to use zip forms class, I teach you how to move those all up. But there it is. San Diego risk management forms. I click on that. And then I see here's the seller property questionnaire addendum right here. All of these that are highlighted are all ones that I've included in this form. So when I do SPQA, I get my seller property questionnaire addendum, and there it is. And so again, please make sure you're using the current form. Again, this one was revised on January of this year of 2023. Okay, so make sure you're using the current form, and it usually, if it's not in the upper part, it's always down here where it says January of 2023. Okay, everybody good with that? Good question, Anonymous. Thank you. Good to see you back. All right, so back to my SPQA. I'm disaster relief. These are things SPQ 9, paragraph number 9, doesn't address these items. So we wrote this in San Diego. Then I get to 10 and 11. There's nothing to talk about because we thought the SPQ did a great job of addressing it. 12, I'm still going to be talking about those boundaries and access and property used by others, overhangs, things like that. 13, just a quick question about standing water. Paragraph number 14, we're going to address condo conversions that were not addressed, clearly not in the TDS, but also not in the SPQ. Paragraph number 14, we got some more questions about common interest. And I'm trying to remember what, shoot, let me bring that back up because I had just those 2 items that were included in the upcoming okay, where is it? Oops, you can't see what I'm doing. Well, hang on a second. I'll have it up here for you in a second. It's my SPQ SPQ revisions. Maybe it's in my, I'm in the wrong one. All right. Give me a second because it's going to be important. I wouldn't be doing this. Here we go, SPQ draft. Okay, so I'm going to pop up my SPQ draft. I'm going to go back to my new share. Here it is. So this is my SPQ draft. This is what's coming out, roughly coming out on December the 13th and so, or 18th. So here is under 8. Here are the questions under 8. Okay, so let's go to 8. So these are going to be my, those have been revised. So let's go back up here to 8 in the San Diego form, and we see he says right here, structural systems and appliances. So a lot of times when I see the revisions, they are actually stuff from the San Diego form. So are there any ADUs? And I'm looking in here and do you see anything about the ADUs? I don't. So that's interesting. That's going to be a departure from what I normally see, which is where San Diego puts something in there, but the then SD or CAR copies it later and puts it together. So, okay, so nothing in that one. But then the other one was down towards the bottom, and that was my whether the property was originally constructed as a manufactured or mobile home, and that's paragraph number 18. So let's go down to 18, and 18 says there's no 18. Where's 18? There's 17. Where's 18? Hello. 18 said, oh, other. Okay, so it's going to be down under other. So this is my San Diego form, and I don't see anything in there. Multifamily, whether property originally constructed as hey Joe, so manufactured or mobile home. So that question is not in our SPQA. So CAR got ahead of us on that, which is great. Great news, right? So again, that's my upcoming SPQ form. So my SPQA again, rolling through this. The items that are not covered by the SPQ, clearly not covered by the TDS. And so some of these are more, there's more to it than others. Paragraph number 15, for example, we go well into title ownership and legal claims that are not covered in the SPQ paragraph number 15. In SPQ paragraph number 16, we felt like these things should be covered in there. Any obnoxious odors, any high voltage power lines, any high pressure gas lines. 17 is governmental, 18 is other. Prior transaction disclosures, clearly not covered by the TDS, but really more of a contractual disclosure. And I know as a big brokerage, anytime we handle a sale of a property that we represented the seller in a previous transaction, we're going to want to bring those disclosures forward and provide those to the buyer in the transaction as well. So is everybody good with that? What else in there? Anything crazy? I think that's about it. The last page is really just this great big long excellent buyer's legal duty to exercise reasonable care. I've had enough lawsuits where the buyer said, well, I figured that the seller's disclosures and the agent's inspections were sufficient. I didn't have to order my own. And so this says, nope, that's not the case. And then we'll talk about that again when we look at the Avid. At the bottom of the Avid, that says the same thing. It's not a substitute for what you're supposed to be doing. Okay, so blah, 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 lots of good explanations in there. So let's take a look. Oh, that's interesting. I don't have my Avid pulled up. So let's take a look. Why don't I have an Avid in there? Did I miss it somehow? There it is right there. And that's the current form. So we'll pull that up here in a second. In the meantime, I'm going to go back to my PowerPoint. So we looked at the SPQA. Again, SDR form SPQA. It is the standard of practice, standard of care in San Diego County. Okay, so I had an attorney call me on the phone. And he said, I'm defending a broker. Let me tell you up front, they did not use the SPQA. And then before I had a chance to say anything, they said, I know it's the standard of care, standard of practice in San Diego. I said, counselor, I don't know what to tell you. And they said, all right, let me get back to you. Anyway, I'm pretty sure they settled the case, but essentially the answer was, yeah, you should be using that form. And so sometimes I see the egos going back and forth, we don't require it. Or I had one broker who said, our office doesn't require it. And I thought, your broker helped write it. So anyway, I got to kick that up to the broker for the company. So we'll have that conversation. Could be a contractual obligation. if you put it in the contract. So that's one of the things that we do, and that is we put it in the purchase agreement. So let me pull up the purchase agreement. Here it is. And this is what our purchase agreement looks like. And I'm going to take us down to paragraph number 4, which is the beginning of page 4. So you see over here in paragraph 4B, other addenda, we usually check the box and put in SDAR forms, APA, LAD, and SPQA, because we do want to make it part of the contract. Okay, so that's what we do. We want the seller to provide that. That just goes that much further forward to getting compliance with that. Okay, so it could become a contractual obligation. All right, so but you got to put it in the agreement in order for that to happen. It is intended to decode those items that the TDS and the SPQ miss. Right. So let's take a look at my Avid. I like the Avid. The Avid's a great form. It's CAR form AVID. And again, I pulled that up just a second ago. You saw me do that. Here's my Avid. So, and the Avid, there are no changes being made to the Avid for the upcoming forms change. So you will notice that it is tied to Civil Code 2079, which is our obligation to conduct a reasonably competent, diligent visual inspection of the accessible areas of the property. Sounds like Easton, right? Okay. All right. So for use by the agent when the TDS is required, or when the seller is exempt. Remember, you do not have an exemption under any circumstances. You are subject to Civil Code 2079, whether the seller is exempt from the TDS or not. So, it's got nothing to do with you. You're not the TDS, you're the Avid. Okay. All right. So up here at the top, I've got my recitals. Again, we put in some of this language to mirror what's in the TDS. So an Avid is required for all the units, or the Avid is used for all the units or only some of the units. I may have more than one. Okay. And then I have the company name in there. And then we have the discussion on what California law requires. And again, I don't know how many times we got to say this part, right? The accessible areas of certain properties, et cetera, et cetera. Okay. So, and disclose to the prospective purchaser material facts affecting the value or desirability of that property that the inspection reveals. Again, right out of Easton. That's where we're taking it as a code, right? It's right out of the Easton case. Okay, so it applies to residential 1 to 4s. Remember, we're trying to protect the innocent 1 to 4 buyer seller. Otherwise, what? Otherwise, we've got the Uniform Commercial Code. Okay, all right, good. I finally got a chance to use that as a prop. So, all right. So California law does not require the agent to inspect the following. So folks, the reason one of the reasons I tell you to read this is because you don't want to make statements that are inconsistent with what it says. Because where this thing says, I'm not liable to do these things, and then you come along and you do them, then you know what? You just cooked the goose, right? I mean, you just made it so that you could be held. I had a lawsuit where the buyer and the buyer's agent were standing down at the dock by the bay, right? So the property was a bayfront property, and it had a boat slip, and the two of them the buyer and the buyer's agent are standing on the boat slip. It's low tide, and so the buyer says to the buyer's agent, is the stem wall okay? And the buyer's agent makes the comment because he thought he was looking at the stem wall. Well, stem wall is still below the water line, but he says, stem wall looks fine to me. Millions of dollars later, okay, and probably one of my highest paying cases, millions of dollars later, the buyer's agent regrets ever having said that, right? Because why? Because they're not an expert on stem walls, okay? So, and it says right in here, we're not going to be going and looking at that stuff, okay? So, for example, we're not going to check public records or permits. It says right here. So why do agents go down and inspect the permits? I don't get that. All right. Areas that are not reasonably and normally accessible. Okay. You don't have a duty to break through a door. Okay. So common areas, stock cooperatives, things like that. Agents inspection limitations. Look at this. Here we go again, conducting a reasonably competent, diligent visual inspection of the accessible areas, normally accessible areas of the property, right? So they just like a broken record, okay? And there's a reason why it's that way, okay? Roof and attic. We're not going to climb onto the roof. We're not going to go into the attic. So please don't go into the attic. Interior, we're not going to move or look under or behind furniture, pictures, wall hangings, floor coverings. We're not going to look up chimneys or into cabinets. or open locked doors. We're not going to break into anything. All right. But I get it all the time. I had an attorney call me up and say, did the agent have an obligation to open the cabinet? And the answer is probably not. Okay. So exterior, not going to inspect beneath the house. I've got agents crawling under the house along with the physical inspector. Listen, you got all those spiders all over you. Let him go, him or her go first, so that you don't you aren't covered in spiders. But why are you doing that? It says right here you won't do that. Okay, so then why did you do it? Appliances and systems, size of property or improvements. We're not going to measure square footage. Okay, so please don't do that. Or identify or locate, right, boundary lines. We're not going to do that. Okay. Environmental hazards. We don't know what mold is. We don't know what asbestos is. We don't know what all these things are. Okay. So, I have a graduate certificate in hazardous materials management. So I got a pretty good idea, but all that stuff, I'm probably going to have to send it to a lab if I suspect something. So I was doing we were doing a physical inspection. I was the agent, the buyer's agent on a transaction in Del Mar. I remember it vividly. It was 20 years ago. I remember it like it was yesterday. Physical inspectors there, John Hasty, God rest his soul, he's passed away, but he was the count. He did probably over 40 years, did all of the inspections, actually a little less than 40, 30 years, all of the inspections that my buyers had done. He's very good at what he did. And he opens up the heater cabinet in this house, built in 48, by the way. And there's the heater, and I'm standing behind him, and he's looking at it, and the heater is wrapped in this sheet. Okay. Now, for those of you who've been around a while, I'm looking at that. I'm going, oh God, it's asbestos. I just know it is, but I can't tell anybody that. But I can tell people to check it, investigate it further. He looks at it. I'm looking at it. He turns around, looks at me. I'm looking at him, and he goes, I think I'm going to recommend further investigation by the buyer. And sure enough, the buyer did further investigate, had an asbestos company come out who said, oh yeah, that's asbestos. Okay. And they figured out that it went all the way up to the ceiling and then went along the ceiling, with the vent. But it only went 22 feet, which is kind of interesting. I mean, it wasn't a big house, but it went about 22 feet. And so they came back and they said, it's asbestos, right? But, I was pretty well certain. He was pretty well certain, but neither one of us can say that because neither one of us has the credentials or wants to be held liable for that statement. Okay. So remember that, folks. Remember, you don't know what those things are. Okay. All right. The sinuses. Okay. All right. So don't opine what you think it might be, but tell the buyer you need to have that further investigated. And in my case, the buyer listened to me and went ahead and had it further investigated. And the sad truth of it was that they had a friend die of asbestosis the year before. And so they were kind of impacted by that. Well, they weren't going to kill the deal. They just asked the seller to replace it, to clean it, to remediate it. Okay. Interesting, because the fix was like 22 grand. And you know what the seller did? The seller refused. The seller has a real estate license. The seller is also a lender. And the seller said, I'm not going to do it. And interestingly enough, the buyer said, okay, if you're not going to do it, we're not going to do it. So they walked. I went off and sold them another house for more money. And what was really kind of sad was that seller was being fairly stubborn and resistant about doing anything. They ended up selling the property for about $350,000 less to the next buyer because they couldn't get, that price for the property anymore. My buyer was willing to pay the price, but they also wanted that asbestos taken care of. Okay, so folks, remember that. Remember that, in some cases, our job is to negotiate, but, taking that hard position, this was the agent owner, took the hard position on it. It cost him $350,000. Well, I guess you could subtract the $22,000. It would have cost him to have the work done. Okay, so off-property conditions, we're not going to do that. Analysis of agent disclosures, right? Agent will not provide an analysis to determine the cause or source of the disclosed matter. So remember what I always tell you, your job is to disclose, don't diagnose. So don't go in there opining on what you think it is. So for example, I had a case where the buyer's agent noted a stain on the ceiling. So they were really good. They put in, water stain noted. I probably wouldn't have said water, but should have just said stain noted. That's all you had to do. Bedroom number 2, northeast corner. That's all you had to do. Okay. Well, instead they added the word water. So what was that? That was a diagnosis. They thought it was water. After closing, buyer goes up into the attic to determine the source of the water leak, only to find out it's paint cans that have been left up in the attic and they're leaking down through the ceiling. And of course, there you got hazmat and all that. Now, fortunately, this was 25 years ago. It was only a $250,000 settlement. But I can tell you that that agent will never use the word water again. Remember, disclose, don't diagnose, don't offer things like that. And so in Linda's office, I look through everybody's Avid to make sure that we're not going crazy and offering solutions. It just needs a little WD-40 or the handle sticks. You just lift it and then pull it. Don't get into that. You keep your job limited to what your job is, okay? So down here at the bottom, this is the part I referenced earlier, what this means to you. So this is important. I want you to listen to this. An agent's inspection is not intended to take the place of any other type of inspection. Remember that the buyer has a duty, a statutory duty to investigate the property. So I had a good question this morning. Somebody asked the question about that duty. How deep does that go? And so for the real estate agent, not intended to take the place of any other type of inspection. The agent inspects, the buyer investigates, the sellers disclose what they knew or should have known. Okay. So I always say that when you go to the physical inspection, if you're the buyer's agent and that's when you're going to do your Avid, inspector goes right, you go left. I don't ever want to see your Avid influenced by what the inspector found when they went through the property. They have a completely separate duty. Okay, your duty is just what you can visually observe. All right, theirs is to dig and poke and do all that kind of stuff. I had a lawsuit in Livenhain where the buyer's agent was in the buyer and the buyer's agent were at the property. Buyer's agent lifts the carpet up in one of the bedrooms, pulls it up, looks at it, and the buyer says, "How's the slab?" And the buyer's agent said, "Slab looks fine to me." Well, of course, in bedroom number 2, there was a 6-inch fissure, and by the way, it was at an angle like this. So they didn't see that from where they lifted it up. They had no obligation to lift that. They should have left it alone, had the buyer have the manometer reading or whatever to determine whether or not the slab was okay. And so in this case, they blew it. It cost them a fortune because they made that statement because they wanted to know everything, and you can't know everything. So nor is it a substitute for a full and complete disclosure by the seller. So I have my agent's inspection, I have the seller's disclosure. So regardless of what the agent's inspection reveals or what disclosures sellers make, California law specifies the buyer has a duty to exercise reasonable care to protect himself or herself. This duty encompasses facts which are known to or within the diligent attention and observation of the buyer. And so, we'll frequently have buyers who will say, well, I figured you told me what you were supposed to tell me, and so I didn't have to do anything else. And that's just not going to be a good defense. Okay. So buyers should, in bold print, and this paragraph, by the way, is usually in 10-inch bold letters in front of the jury. Buyers should review any disclosures obtained from the seller. Of course, right? Obtain, and by the way, you as the agent should go over those disclosures with the buyer if you're the buyer's agent, all right? So obtain advice about and inspections of the property from other appropriate professionals, okay? And review any findings of those professionals with the persons who prepared them, all right? So in other words, don't call me, call the professional that created it, and let's see what you can find out. Now, a lot of times your buyer will call you and ask you to make that call, and the answer is no. It's personal to the buyer. Let the buyer do that, okay? The buyer needs to do that. And the buyer needs to be present during the physical inspection. Okay. A lot of times they'll blow it off. I've got a job, so it wasn't important to them at the time. But of course, after closing, it's very important to them. Okay. So that's page 1. Notice only the buyer initials page 1. Okay. Then I go into page 2. So if this property is a duplex, triplex, again, the same language from the TDS, here's the inspection was reported. And again, this is our template. So there's our name in there. There are 2 fields here. In fact, let me pull up the hot version of this. So we're going to go to let me pull up the Avid as it appears. I just can't highlight any of the paragraphs. So here's my Avid. So let's go to page 2. You all can see that. Yes. So here, notice there's a place for me to put the date. So it needs to have the date. And then the next part is the time. It needs to have the time. Okay. And then weather conditions. It needs to have weather conditions. This needs to be filled out. These are some examples of things that we've seen filled out on Avid forms. So you need to be able to defend the fact that you actually did your Avid. And so date, time, weather. Now, if you put in, I'm going to pull up a drop down. You put in sunny and clear. And then plaintiff's counsel goes and looks up the weather on 12/5, and it says it was raining cats and dogs, right? Then you're cooked. This says you didn't do it, you lied about it, you put in the wrong date, whatever. It's not going to work. Okay. Other persons present. So you're going to put other people that were actually there, put their names, whatever, the physical inspector, whatever. Put that information, because you have witnesses. You have witnesses that were there. And so you need to have a witness. Essentially, if you don't have one, you don't have one. But if you have them, put them in there. It doesn't hurt you, right? So, I did my Avid at the same time the physical inspector was there. But Kevin always said, physical inspector goes right, I go left. And that's what I did. Okay. All right. And then again, here's my language: based on a reasonably competent, diligent visual inspection of the reasonably and normally accessible areas of the property. Are you getting tired of hearing that? It's right out of Easton again and again and again and again. Okay. All right. In fact, it's also quoted in Field. Okay. All right. So then now on page 2, so page 1, there was nothing for you to do, right? Page 2, on the other hand, talks about the interior of the property. So if you don't notice anything, then, add a clause. So if you don't notice anything, nothing noted. Okay. Now, your whole form shouldn't be that way, because you need to defend the fact that you actually did it. But if you see something, so you can put in scratches or buff marks or such and such on the kitchen counter, whatever. Don't get into a huge full-blown explanation of what it is. It's not your purview to do that. Okay. So on the Avid, just note what you know, and don't go into any more depth than that when you do it. Okay. All right, so excuse me. Okay, so I'm going to delete that, because unfortunately this is our template, so I don't want to mess up anybody that's using our template. Delete that, and then I'll get rid of sunny and clear, and the rest of that I can leave. And so obviously living room, dining room, kitchen, other rooms, bedrooms, we've gotten away from master bedroom. Now it's just whatever, number 1, number 2. So bathrooms 1, 2, and 3. You may have to go to a separate form. Okay. So I would use the addendum for that. But this is your Avid. Then I go to page 3, and now I talk about the exterior of the property. So I want to make sure that make sure that I've looked around at these things and put those things in there. Almost 99% of the time, garage parking, excluding common areas, I almost always see cracks noted in driveway. So cracks noted, CACs. Okay. I can spell. Cracks noted in driveway. I think that's the safe. I'm going to leave that in there. That is probably the safest thing you can say about the driveway. I've never seen a driveway that didn't have a crack in it, right? Okay. So I'm not going to get into cracks in asphalt versus cracks in concrete. I'm just going to say cracks noted in driveway. I've just never seen a property with a driveway that didn't have a crack in it. Okay. So these are the kinds of things that we're looking for the agent to write. I don't want to see minor settling cracks or routine or 13 hundredths of an inch deep crack. Don't do that. You're not there to investigate. You're there to inspect. Okay. All right. And then down here, this is the hot button. So this is the DRE looks at this. So this disclosure is based on a reasonably common, diligent visual. There we go again, all that language. Okay. Notice it says signature of associate licensee or broker who performed the inspection. And so this is what the DRE is looking for right now. And they're going in and they're going after teams, right? Because the team leader, let's assume it's me, doesn't do the inspection. Somebody else in the company does the inspection, and then they hand it to the team leader who signs it. And the DRE has said, we think that's fraud. Okay. And when the DRE uses a 4-letter word like that, run, don't walk. Okay. So we think that's fraud. So even Joe, we were doing the Avid on the Lake Forest property. Joe did the Avid. I didn't do the Avid. Joe did the Avid. Joe signed the Avid. Okay, Joe's name appeared in here, even though I don't even remember if it was Joe was the listing agent or if I was the listing agent, but I know I didn't do the Avid because I spent 3.5 hours sitting with the seller going over all of the disclosures, right? And then Joe went around the property and did the Avid. And he did a great job on the Avid, and he signed the Avid because Joe did the Avid. Is everybody good with that? Okay, all right. So Joe signs it. If somebody else signs it that says that they performed the inspection and they didn't, the DRE is coming to talk to you. Okay. So then down here, more language, though not all defects are observable by a licensee conducting inspection. Inspection does not include testing. Licensees are not home inspectors or contractors, and you need to obtain advice from those professionals. Okay. So the buyer signs under this. The seller could initial, but only to confirm that they've seen it. And then again, the signatures are stacked. So the seller's agent will sign first, and then the buyer's agent will sign last. And now I've got an Avid. And remember what I said earlier, the TDS is not considered complete until the seller's agent's Avid is given to the buyer. Okay, so the TDS and the seller's agent's Avid in order to round out that window to complete that TDS. Not the buyer's Avid so much, buyer's agent's Avid, but the seller's agent's Avid must accompany the TDS or it's not complete until it does. Everybody good? Questions? Nope. Okay. All right. So ACE's visual inspection disclosure. Remember, the TDS is considered incomplete. I just told you this until the seller's agent's Avid is given to the buyer. So page 1 again was disclosures and indemnification. Page 2 was the interior of the property. Page 3 was the exterior of the property. Remember that your job is to disclose, not diagnose. And I always like to put that in there in big letters. Do not offer an opinion as to what the cause was or what the fix could be or what you think it is or solar flares or whatever. Stay out of that. Okay. All right. So statutory disclosures, one that's required by law. Statutory disclosures contain rescission rights. Failure to make a statutory disclosure may give the offended party a right to reset the contract. Okay, so in other words, put the parties back in the position that they were in prior to contract. And I don't know why it's this is right back over to what we did before. So I'm going to fly through this. Oh no, actually, this was this morning. So okay, so contractual disclosure is one that is required by contract, determined by the contractual relationship between the parties. Contractual disclosures contain cancellation rights. So statutory disclosures contain rescission rights. Contractual disclosures contain cancellation rights, and that is maybe give the parties a chance to exit without penalty. Again, not your decision. You don't know whether that's going to work or not. If the buyer says, I want out of the transaction, you say you need to talk to counsel. I can't get you out of contract. But I want to thank you for joining us today. So does anybody have any questions about anything that we covered here? Looks like I'm going to get us out of here a couple minutes early. I'm kind of surprised by that, but I definitely bill in 15-minute increments. So we're into the last quarter. Okay, so TDS, SPQ, SPQA, Avid. I told you earlier, get your QR code reader ready. Here you go. Click on that. And now you'll have access to the YouTube website where all this stuff is. Somebody sent me an email today asking me for the link to it. And then of course my comment is you've already got it. So good. So you can also type into your browser at Burke Real Estate Consultants Inc. Case is important here. I've also created a bit.ly link. So bit.ly/real-estate-ed. Case is important. This is all lowercase. Again, I had to learn how to do all these things because it wasn't being done. So please remember to like and subscribe. So please, when you go there, and I hope you do go there, like it. That just makes me feel good. Subscribe to it, because if you subscribe to it, it'll notify you when I update anything. So for example, I've already loaded this morning's presentation on all about disclosures. It's already in there. If you were to log into YouTube, it would say, hey, Kevin loaded that, that all about disclosures earlier today. When I'm done with this one, it takes a little while for the program to process the video. They got to take out all my bad language and stuff like that. But at that point, I will load that as well. And then Thursday, we're back. We'll do more stuff, and I'll load that as well. And then, as I said earlier, next week, we've got Tuesday, Thursday. We have morning and afternoon both days, and then I'm done. I don't know. It's up to SDR to invite me back. So I don't know if I'm coming back or not, but again, we always hope. I'm all about the membership, folks. I don't care about anything else except the membership. So I want to make sure you're okay. But regardless of what happens, I will be doing podcasts. I just did the podcast for the Department of Real Estate. If you go onto their website and click on consumers, in fact, I can show you. Let me see, because I don't even know. I haven't checked to see if it's live yet. But let's say we go here, and then I'm going to type in DRE. You can tell I go there a lot. Consumers, right here, consumers. And I'm going to go down here to First Home California. I'm going to click on that link, and then they still haven't put it up there. What's going on? So they asked me to do a podcast, hour and a half, by the way, on legal documentation and matters involved in a real estate transaction. And so I put that all together for them. I'm kind of surprised they're a week and a half late on this, but I'm hoping it's going to show up there fairly soon. It was supposed to be launched on the 29th, so it'll get there eventually. Thank you, Rachel. So anyway, so just be aware of that. I want to make sure you're okay. Let's see what else. If you want me to do a class, I can come to your office or webinar your office. I've done a lot of those on behalf of the association. So send education to SDAR an email, copy me, send it to me, copy them, whatever you prefer. I'm here to help. I want you to be okay. All right. And then I have a weekly email that goes out every Friday. And in that email, it says, here's links to my classes, so you have a direct link. Plus, also you have access to all the new forms, all the new laws, what the DRE's position is on certain, multiple offers, things like that. I have all these things saved right there, so you don't have to go looking for it. But again, I don't put anybody on the newsletter unless you ask to be put on it. So it is opt-in only. I have a lot of subscribers. I don't charge for it. There's nobody trying to sell you anything. I just want you to be okay, as I've said before. So that should round it out for us. I hope that helps everybody. I value your time, so I am going to let you go a couple minutes early. This is kind of rare, but I want to thank you all for being here. And if there's anything I can do for you, I hope that you will let me know. And as I always say, from my hometown of Del Mar, I look forward to seeing you around the track. Thank you, everybody. See you on Thursday. Take care for now. Bye-bye.